to be heard. But the more important point that I need to point out at this stage is this, that, my lords, under the Constitution of Kenya, you cannot be an investigator, a complainant, and a judge, and a juror, as it seems to be the case. The case of Kinoti versus Chief Magistrates Court makes that point in better words that we can do. We have quoted that in that case, even a gazette notice that had been done by the DPP was nullified by the High Court on the ground that it purported to collapse those three roles to some officers appointed by KRA. So that if in the normal course of things, the High Court protects ordinary people charged with regular offenses, that your due process rights cannot be taken away. It is all the more important, my lord, that also be accorded to the first petitioner, unless there is any good reason that, and there is a principle of law that says, no man is too high or too low to be unworthy of the protection of our constitutions. My lords, I urge that fundamental failure of justice is inexcusable and can only lead to one decision. There was no proper vote for the impeachment of the first petitioner. That, of course, goes with the issue of saying, and now that is the next issue, on whether the first respondent, the first petitioner is a subject or is a victim of a political conspiracy. My lord, it is important to point out that, because this is where my clients are very much interested in, that under Article 75 of the Constitution, when a person has been removed from office, 75(3), that person is disqualified from holding any other political office. My lords, the first petitioner is interested and he holds a political office, is a politician, and politics is a transactions between leader and people, as it were. We are here because I represent members of his constituency. And because of that particular reason, it is why the petitioners I represent would be very careful about the prospect of the leader of that constituency being barred from contestations of the political office on account of an extremely tragic and defective impeachment. Why does this matter, and where is the entry point? My lord, we have Article 1 of the Constitution. Sovereignty vests in the people. We have Article 38 of the Constitution, the issues of political rights. The Supreme Court has said, adopting a certain memorandum on standards of impeachment, basically saying that impeachment proceedings must be carried out in a manner that ensures those fights that should be resolved by the people through normal democratic elections are actually solved by the people. So that the right to form government is a right to govern together. That is what Ben Wabweze told us in very many books that most of us quote times without number. The right to get power is a right to govern together. We have annexed the Memorandum of Kenya Kwanza. We have annexed UDA. UDA itself was an alliance that all said what after getting power we were supposed to do together. There was a breach of that democratic contract. That is not just a breach between the first petitioner and the sixth respondent. It is also a breach between the constituency that expected certain representations by its consciously appointed or selected leaders would partake in the governance of the country. Your Lordship, sir, this matters because elections matters in a democracy. But my Lord, the High Court, as a guardian of the constitutions, cannot countenance a situation that in 2027, when we shall be doing an elections, if I figure out that Paul Muite is a very popular leader and he should seek power together with me, in a democracy, the mandate you get from the people is that you will govern for 5 years with Paul Muite. But my Lord, if it turns out that Paul Muite gets you to get to the office, and then 2 years or 1 year down the line, you want to remove Paul Muite and replace him with another person, two obvious questions would have arisen. And that question is, why did we have to go to the elections? We go to the elections in order to get the political elite that will be responsible for our statecraft for 5 years. But it turns out, my lords, that there is any single person alone or in conspiracy with others who can be able to change the nature of the democratic mandate obtained through an election. That would be a grave violation of democracy as ordinarily understood, but more importantly, of constitutional democracy in our country, because the constitution of our country, I think the Article 3(2) says it is unlawful to establish government otherwise than in accordance with the constitutions. In Kenya, government is established pursuant to an elections. It is therefore, my Lord, our submissions that a scenario in which the very foundations of our democracy is contested, becomes disputed, that state of affairs cannot be permitted. Recently, in the case of Governor Guyo, a 3-judge decisions of the High Court explained, we have quoted it somewhere, explained at length that the nature of our constitutional democracy is that you must respect the people. The people appoints you in this party, gives you a mandate to govern with this manifesto. That must be respected. Because if it doesn't, democracy fails in the most fundamental sense, that it ceases to be a transaction where government, in the words of Abraham Lincoln, is a government of the people, for the people, and that is supposed to serve their purposes. So that, my lords, for purposes that happened, water under the bridge. The first petitioner said, I no longer want the office. That right must be respected. But what is important is this. Still on account of the same impeachment, if there can be no lawful government in my reading, in the reading of the petitioners I represent, between the impeachment of the first petitioner and the next general elections, it is important that the government that comes to office in Kenya in September 2027 will be a government established in accordance with the constitutions of Kenya. How do you get that government? That is the entry point. How you get that government is to ensure power is contested by everybody eligible on account of the constitutions of Kenya, without limitations imposed politically in order to secure political advantages. The case of conflict management, the ICC case, what was it all about? William Ruto and Uhuru Kenyatta are having ICC charges. They are not eligible to vote. The High Court decided many things. Some of the three that are important, that I wish to highlight, that he decided are: number one, that the issue of who governs Kenya with a written constitution is a decision that belongs to the people. The people are the best suited to decide on that issue. Issue number two that you get from that decision is that, given the history of our Kenyan nation, we had situations, you had it in 1969, you invoke a rule of procedure to get all candidates of Jaramogi's party debarred from contesting office. You had a situations whereby you could say that the day of nominations are 2 hours. Then you abduct your opponent. Your opponent does not submit their papers. Those are the kind of things that, in retrospect, the High Court in that case was saying are not permitted under the Constitution. That Article 38, the right to seek public office and to be voted, mean exactly that, and must be respected and cannot be derogated without justification. Issue number three from that case was this. It was the fact that, and that was for TNA. TNA had nominated William Ruto and Uhuru Kenyatta for their ticket for that year. And I represented TNA in that case. The right for TNA and its members to have William Ruto and Uhuru Kenyatta contest the elections was upheld on the ground that politics means nothing if the leader that best expresses your political aspirations in politics can just be disqualified, can just end up not being a candidate. So they upheld that right and said, for that right to be taken away in Kenya, very onerous standards would be required. In the case before you, my Lord, that onerous standards would be this. I'm about to finish.
Please.
Yes. That onerous standards would be this, that we have actually confirmed that there was a good impeachment. There was no malice. That we had a good parliament that could do the job. But what are we facing, my lords, before you? The scenario that we are facing is that we used to have the 6th parliament. The parliament that we had between 1988, the 6th, 1988 and 1992. It is a parliament that got rid of Dr. Karanja from his office in a manner that was described properly. Now, we also have the 13th parliament. We have its record of impeachment. I thank the lawyers for Parliament for giving us the full answered reports. You read them. If you are with foreigners, we have read impeachment proceedings in other countries. I wonder how proud one would be to say, these are Parliament. But that's not the important point. The important point is this, and we have the head quote of Sifuna. Before somebody can be able to say that we do our job, we honor the constitutions. Constitution says Parliament be independent. It says protect the interest of the people. We have on record in our head quote Senator Sifuna saying that he had observed, he said that in an interview with Cyrus Jirongo. He said that he observed that when the issue of the reductions of money to counties